Hello, everybody. I won't say good morning because I know that at least one person here is in Australia, Alan Limbury. So welcome to you. And also Mary Rosemary Howell is equally in Australia, I think both of you, and anybody else who's outside the UK, you're very welcome. We've got, I think, 31 people on screen at the moment, and we may well get some more that they're coming along as we speak. We'll invite everybody who's a first timer to introduce yourself after we've had the main part of the meeting. So for the moment, I'd like to introduce Mary, who you should be able to see on your screens, Mary Banham-Hall. I've known Mary for well over 10 years, and in the capacity when she was in charge of Focus Mediation, which based in Milton Keynes, a very diverse group of mediators. Mary is passionate, has been passionate about mediation, less so now because she's officially retired, she tells us. Mary has a background of being a solicitor. So Mary, can I hand over to you? I think you said you'll probably speak for about half an hour and then take questions after that. You're on mute, Mary. You're still on mute.
It's gone.
That's it.
How can you hear me?
Yeah, yes, we can now.
Thank you. It may be between 30 and 40 minutes. I did a bit of a run yesterday and I've got so much material which I think is relevant to what you're all having to cope with at the moment that I'd like to get across. And if there are questions we don't get to, let me know later via Dave. So I came out of UCL with a law degree in 75, qualified as a solicitor in 79, and became a mediator in 1999, family, 2002, civil. I was a solicitor for 40 years, so I did a dual practice for a while, and a mediator for 22 years. Set up Focus 1999 and got a legal aid contract in 2000, which I kept for 17 years. So I have quite a lot of experience of dealing with what was variously named Legal Services Commission, Legal Aid Board, Ministry of Justice, going way back a long way. And I stopped mediating during the pandemic. I didn't like mediating online. I think you lose a lot, but that's another subject. I've got quite a lot of information, facts, insights from my 22 years as a mediator and earlier life full-time as a solicitor. I've got a lot of docs. Some of them are a bit out of date, but they might be useful if you're campaigning or trying to change things. And I've had various negotiations in the past with the legal aid people and indeed the Ministry of Justice, which I think you may find extraordinary in some respects. So just going back to prehistory, but briefly, because it's interesting. 1949, legal aid was introduced. It was almost unlimited in scope, with people qualifying really without much difficulty. And legal aid chugged along through the 50s, 60s and early 70s without being a problem for anybody. But by 1986, legal aid cost 342 million in that year, which was felt to be rather a lot. And it continued to rise. And despite frantic cuts and limits in eligibility and what have you, in 1995, legal aid cost 1.4 billion, which is a lot. But after the pandemic billions, I'm not quite sure that it sounds as bad as it did at the time. 1997 was an interesting development in mediation, because this was the first compulsory assessment for mediation. So this was the first time the government had taken steps to reduce costs using mediation. What did they do? They made it the rule that nearly all applicants for legal aid only had to attend a mediation assessment meeting with a mediator. That's critical, because otherwise it won't happen properly. They had to have that certificate before they could apply for legal aid. Interestingly, it was estimated the number of private mediations which took place the year before the implementation of compulsory assessment for legal aid applicants was about 600. I've got all this stuff. You can have my notes if it helps. The first year of MIAMS, with the early adopters of mediation and everything, 14,500. And these were the effectively the small claims cases, if you like, because one or both parties qualified for legal aid. The other party, interestingly and importantly for you, had to pay for their own MIAMS, I think, or perhaps that came later. That may have come later, but they had to pay their own costs. So that is the effect of an element of compulsion. And one of the things I think is critical for you is that you don't have the wrong sort of compulsion at the wrong stage, because it will drive you potty. So 2002, interestingly, this is random but fascinating, and it shows you how things can work in government. They privately funded mediators with legal aid contracts were always paid a simple amount. It was pretty understandable. In 2002, the government said, no, everybody's going on the same contracts. And this actually meant, to the astonishment of the not-for-profit charitable sector, that a lot of them had to have cuts. So despite being in often subsidized premises and everything, they were paid more than the for-profits or privately run mediators. Just interesting. And those costs have not changed really for 20 years, which is why in 2017 I gave up legal aid, and loads of people have had to give it up because you can't actually, it's not profitable. And I would say proceed with huge caution getting the government to pay for anything. And I'll come back to that in a minute, because you're better off with people having to pay for those things which they have to pay for with solicitors. And why anyway would the MOJs got to cut costs yet again, offer to pay for something, i.e. mediation assessment, for privately funding clients who are paying for their legal proceedings anyway? I don't think they will, but I don't think it's going to help you much. And I certainly wouldn't go down the voucher thing either, but that's another issue. So in 2007, there was a national audit report into legal aid family mediation. And I have that report. It is extremely interesting, with a lot of material in it. A lot of it is just as relevant now as it was all those years ago. There's a bit at the end of my notes which puts in a slight bit of it. Mediated legal aid case, average cost £754, non-mediated legal aid case £1,682. Legal aid case is 110 days, non-legal aid 435. It's all there. It's not going to change, that sort of thing. So in two things that I haven't actually, that don't fit into the timeline that I'm going to mention, is the costs of legal aid family mediation litigation. This is private family litigation for which people had legal aid, not public law or child protection. The last year there was legal aid for private family law applications was about it ended April 2013, was 360 million. Do you know how much? I don't suppose you do, but I'm going to tell you, they were paying on average year on year for family legal aid, family mediation legal aid. It was 14 to 16 million. Just think about that and what they were getting you to do for it, and all the bits that you have to do that's not in the price of what they will pay for. Just remember all that, because there's plenty of it. And then there's the audits, which will make you tear your hair out. I won't, that's a big subject. The other thing is, just think about how many litigators there are in England and Wales. Solicitors, barristers, paralegals, legal execs, all these people, probably scores of them in every single town in the country, plus God knows how many in London and the big centres, making a living out of litigation, family litigation. And then think, how many mediators have we established actually make a living out of mediation? It's still under 200 in England and Wales. You know, these are the basic issues that have never ever been addressed. And if there is an appetite for change now, this is the time to get things put on a sustainable footing, not one that's going to kill everybody. So 2002 to 2013, very interesting time, because the cost of the legal aid proceedings budget was mounting, despite mediation and going on in the background. Family mediation was particularly under attack because they got rid of it for almost everything else. So they're no longer searching for ways to cut the costs of legal aid, because they're just doing it. They're reducing eligibility and making it more and more difficult. But they're looking for ways to reduce the court budget. And in April 2013, they abolished legal aid for private family law proceedings, except when there was extreme violence and things which have been subsequently narrowed and narrowed and narrowed. And the idea was that the mediators would help everybody. So what actually happened is, leading up to this, there was quite a lot of kerfuffle in government, and certainly an enormous amount of trouble amongst family mediators. And because they could see what was going to happen. You know, the car crash approaching was no compulsory legal aid MIAMS, no general compulsory MIAMS, no work for a year. And I can remember going to Petty France, which was a civil service meeting with MPs and senior civil service. And the mission was for the mediators who ran businesses like myself to tell them how to find ways to cut family court costs without spending any money. Is that where we are today with civil? I think it might be. And I said, it's easy. And a senior woman MP, I thought it was the minister, but I don't think it can have been, came and sat down next to me and says, how do we do this? And I said, introduce compulsory MIAMS for all would-be applicants to the family courts, not just people who want legal aid. It's that easy. And they must pay for them, because they pay for their lawyers. And unless they get legal aid for family mediation, which costs you peanuts, it's 14 to 16,000 a year. Don't tell me you can't afford that. You've got to run a justice system. The cost of the state's almost zero. So she says, do you mean non-legal aid applicants don't have to attend an assessment meeting? I said, we've been lobbying for it for blooming years. Oh, she said, they're treated differently. Yes, said I, since 1997. Her astonishment and dismay was palpable. And so there was change on that one occasion. And unfortunately, there was a great gap in what they did, because the first rule is, and it's a critical issue, politicians and civil servants often don't have the most basic mastery of the facts, but they all start talking before they understand what they're doing, and they repeat received wisdom, which is often wrong, and go off on a complete wild goose chase half the time. No one was listening to people saying, you could do this, you could do that. But this is your opportunity, because you can say, well, we're not doing that, but we'll do this because it'll work. And we know it'll work because we've got the facts. The second thing that happened was they said we're going to abolish legal aid for private family law applications in April, and there was terrible dismay amongst the family mediators, because we realised immediately we were going to lose all our compulsory MIAMs, because we were only getting the legal aid applications at that time, but they weren't going to exist because nobody was going to be applying for legal aid. So we had a meeting in London. And this was my Agincourt moment of my professional career, because they got politicians, and Lord Wilson was there because he was chair of the FMA at the time, and a whole load of other people. And the mediators saying, well, you say you're bringing in these compulsory mediation assessments for all applicants to the family courts, all private applicants, in April 2014. What are we supposed to do for a year? Well, we can't do anything else. We can't fill that gap. You're all going to have to manage. So I said, this is impossible. You're going to be deluged with all these compulsory MIAMs in April 2014. There's not going to be anybody to do it, because vast numbers of people are going to go to the wall. And it was more than decimation, because it was certainly more than 10. I just went back and did more legal work, but not everybody's in that position. So we had a year of dismal falling mediations, very few MIAMs, very little mediation. So it shows you the effect of compulsory MIAMs if they precede something people want, like legal aid or applying to court. And in 2014, despite the year they brought with nothing, and people able to supply it reducing hugely, they brought in these compulsory MIAMs for everybody, and people who did qualify for legal aid could still get it. Did that produce a demand for the extra? I think it was several million they offered extra to pay for the extra MIAMs. Actually, no, because people weren't getting legal aid for it because they didn't qualify, and they subsequently cut the eligibility even further and further. So we had in 2013 Jackson LJ's ADR handbook. Do you remember it? It was going to put mediation at the centre of dispute resolution. It was going to solve all our problems. It was sent to every single district judge and judge in the land, and they were all supposed to get on and make it work. It even had a paragraph telling you how to avoid court sanctions if you didn't want to mediate. That was quite interesting. Well, it came out 2013, and as luck would have it, I had a copy when I had pleurisy one day and I couldn't get up. So I spent a day preparing a presentation for the CMC conference. That presentation was about embedding mediation in the dispute resolution system and making it work, because I wasn't convinced that Jackson would work. And indeed, my mission that year, 2013, how to reform our dysfunctional justice system where costs frequently exceed the value of the dispute, was very well received at the CMC, where I was cross-examined by a bank of people from the Court of Appeal, which was quite nerve-wracking, and the Chartered Institute of Arbitrators and the NFM. And the work is available, you can have it, it's got quite a lot of information in it. The only thing that it possibly do with updating particularly is the case histories where the costs exceeded the value of the case. The old Drains case, value 4,000, cost 300,000, nobody's limited the costs. Mad, there were loads like that. So I carried on lobbying. One of the key points of how we reform a dysfunctional dispute resolution system is not just compulsory pre-issue or pre-defence MIAMs. It was making a court rule, which is in the family procedure rules and in the civil procedure rules, the CPR, which says that costs must be proportionate to the value of the dispute. That has been there for donkey's years. As has another one, which from memory is something like judges are responsible for making sure that cases take up a proportional, reasonable amount of court time, court resources, because you can't just have unlimited court time. And my proposal was, after discussing it with clients and all sorts of professionals, you know, what do you think is reasonable? What should people be able to spend on litigation, bearing in mind you've often got one willing and one very unwilling party? Is it 10%? Is it 50%? What is it? Well, is it 20%? And clients, when I asked them, thought it was just madness that costs could possibly exceed 10%. They couldn't think, you know, 20% was about as much as they were prepared to talk about. And lawyers, I mean, one lawyer said to me, oh, I hadn't thought of it like that, even though it's in the rules. And we all know as mediators, when we mediate, frequently we get the case when the costs have exceeded the value of the dispute, or they are the value of the dispute, or the case won't settle because the costs are so high, or they've become existential for somebody. And yet this court rule, which has lurked there for decades, as far as I can see, still doesn't work. And the reason it doesn't work, it doesn't mean anything smart, specific, measured, achievable, whatever, you know, but we can put that in the court rules. It should be there. It should be in all the proceedings. It should be discussed at every court hearing, every directions hearing. There should be a standard paragraph in the directions. There should be a standard paragraph in the court orders. What is the total value estimated of this case? You probably have to put in a notional amount for cases without exclusive clear values, but you can usually work out, you know, what ought to be a reasonable amount. The judge could decide that people should be allowed to spend on fighting before they actually take some responsibility with help to sort this out for themselves. And I've always suggested, and did in 2013, no, not much, it's not done as much good, that the appropriate percentage is 20% of value. That's what I think the limit should be before people are really arm wrestled to go to an assessment. I don't, for reasons I'll come to, think actually forcing people to actually mediate and do things will be something that is useful to mediators, because you will end up engaged in many, many, many hours of unpaid time sorting out mischievous people who've put toxic reviews on your website and in Google and Trustpilot, just completely. I mean, there's some mad people out there who do some ridiculous things, and they will. Oh, I've had 2 subject access requests for data protection by people who were forced to come to an assessment, and I can tell you neither of them was sane. But the hours they took up were huge. And this is what you will get if you have too much compulsion of everybody. You need to somehow let those people be told, because we can't tell them anything, but a judge can tell them. So spring 2016, I published a novel, Love, Lose, Live, Divorce is a Roller Coaster. This is a novel about one family's sad, acrimonious and destructive divorce. It showed the avoidable costs. It showed the desperation of the 3 children, took you into their rooms so you could hear what they were saying, took you into the solicitor's conversations with the clients and how badly things went, and ended up with a sort of a civil type mediation done by a family mediator, I think it was. And Lord Wilson was kind enough to do the forward, and at the back there is an analysis of all the things that are wrong with the conventional adversarial system and how it exacerbates things and why mediation is better. I've got some spare copies of that. If anybody wants one, tell Dave and give you your address. I'll give a few out, and when they're gone, they're gone. So in autumn 2016, because I'm a bit of a campaigner, I launched a petition on change.org. Has anybody heard of that? So what I tried to do was, and the elevator pictures and things cover this, was try and get across to people that our system was dysfunctional, for court system was dysfunctional, and we need to limit costs by making them specific and having these mediation involved. The fact is, I come to the conclusion that change.org is good for really simple things, you know. For complicated things, it didn't really work. Or added to which, mediators tend to be so busy trying to make a living out of what they do that not all of them got engaged, even though the professional bodies were quite helpful about getting it out. Not everybody read it. So we didn't get anywhere near enough to get a parliamentary debate, which was my dream, but I did it. And that was very interesting because it led me to do some research which is equally relevant to you today. And I'm going to give you the information because I think it might help. So in 2016, CEDA had done one of its biennial reviews. So the 7th review tells us about their survey of civil and commercial mediation in England and Wales. And they estimated the current size of the mediation market in 2015 was 10,000 cases a year. So I thought, well, what percentage of possible cases that could have been mediated is that? So I Googled online for a while and I found something called civil court statistics, which are provided by the government on a quarterly basis. And I excluded the family ones because they were dealt with differently. I can't remember all the detail, but what it showed, if you annualized one quarter's figures for 2015, the civil court stats showed there were about 1.56 million claims, excluding the family cases, of which about 252,000, so about 250,000, were defended. So that 250,000 cases, that was the number that I thought were possibly mediatable, because you don't want pre-issue, because such a huge number of cases, there's no defence. So there's no mediatable dispute. And I thought, well, if you've got 250,000 defended cases and just 10,000 were mediated, crikey, that's just under 4% of all possible disputes. That's not very many, which would explain why we got so few people making a living at mediation. And then I used that in the change.org petition because I thought this is insane. And even now, I don't know what that figure would be, but I tried to do some calculations on the 9th report for 2021, which was difficult because I hadn't got the civil court statistics, and anyway, they're distorted by the pandemic and people not being able to issue. But I think the maximum it could possibly be even now is about 7%. So you've got some massive structural problems built into the existing system. So I still keep coming back to the point that I think is your way forward, is that governments want to save money. The MOJ is desperate to get down court costs, and closing the courts is not actually going to get rid of the demand. They want a solution. They'll chuck everything at you because they don't want it. And you will be buried in a lot of rubbish that you can't make a living at, that will drive you insane if you aren't careful. People have a right to expect to engage a functional dispute resolution system in this country. I mean, we have a reputation, don't we, worldwide for justice, but justice does actually encompass dispute resolution, not just winning a case, because I think about 2% of cases actually go to trial. It's not a lot. And I think your most powerful argument is the costs one. How can we say we have a good dispute resolution system when people are regularly spending more than the case is worth on costs? How is that functional? It isn't. So I will...
Mary, can I just interrupt?
Yeah.
Interrupt a minute. I think we're about 30 minutes in.
I'm going to cut out some stuff. You can have the notes.
Okay.
I'm just going to have a quick look to see if I've missed anything that is. Oh yeah, I've had a couple of important points. Mainly in the CMC representation to the MOJ about what you're after. At Focus, when I left, we were nearly at 16,000 referrals just for family mediation. So these are cases that might have gone to a mediation assessment. Of those 16,000 referrals, I can promise you that not all of them go to assessment. If you are paid by the state for these, you will only be paid for them if an assessment takes place. So what happens is clients play games. They don't give you the name and address of the other person. They give you the wrong address. They give you some digits out on the phone number. They give you the wrong email address. They destroy the letter when it arrives. They hack into their email account. I can't tell you, but there are hundreds of them with family. I don't see that it would be entirely different with civil. And so you'll get all these referrals and you'll do hours of telephone work dealing with crying, angry people where you can't get a word in edgeways, and them really wanting you to do the MIAMS on the phone before they come to the MIAMS. They won't want to pay for it, and the I don't think you'll get the money from the MOJ. The MOJ legal aid people certainly would never pay for an assessment that never took place. So all those referrals that go nowhere, you're doing for nothing. That's probably taking your hourly rate down somewhere close to an assistant at Aldi if you're not careful. The nicer you are, the more you'll do and the more you'll suffer. You'll fry your brain. And secondly, of all the assessments you do, and they're usually separate, and separate assessments are less likely to convert to a mediation, a huge number of them won't start mediation, because it's voluntary. And if you've got cases which are not voluntary, the games that could be played by people whose life is conflict and winding up the other person and driving them into the ground, people who might be narcissistic or psychopathic, you can't deal with them. The hours they will take up will devour you. So I'm supposing that you will end up with a pipeline like that. And at the top will be the referrals, and then the pipeline will go down and there will be the assessments, and then you will get the mediations. You only make money at mediation. You don't make money at MIAMS, and you certainly don't make money on MIAMS which don't happen. That is a fact based on 20 odd years experience and 16,000 referrals and doing the stats on them and everything else. So that's a big one. I think you've got to accept that mediators can't tell people what to do. Sometimes it takes a judge to tell people what to do. And if people are slightly mad, judges think, oh, that must go to mediation. That's highly emotional. You know, we can't deal with that. But actually, sometimes a judge has just got to tell a client, you can't do that. You're not going to get that. And please listen to me, or give this piece of evidence because we can't do anything without it. Sometimes people have got to be told. And what this is going to require is a revolution between lawyers and mediators, because I think you need a parallel system. And I think mediators and lawyers need to understand each other better and respect each other better, and not just try and dump all the rubbish on the other person. So because that's what it looks like to me, and has been for a long time. When we had compulsory MIAMS for court applicants for family law private applications, did they limit them to small cases? No, everybody was referred, everybody. Is there any particular reason why a £2 million case shouldn't go to mediation assessment early on? The family ones did, and still do. Why just give people the stuff that is going to bury them? Because while you're buried, you can't actually do all those things that I made myself take myself out of work to do, to work on the business of mediation. They won't be being done. unless the professional bodies get together and do something I did consider and ruled out as unaffordable, which is raise a levy on mediators to pay a professional parliamentary lobby company to lobby for change, because they do actually listen to lobbyists. There are things that could be done. Okay, I'll try and answer questions if I possibly can. And I hope that was helpful.
Thanks very much, Mary, so far. If you've got any questions, if you can use the reactions hand up icon so we can take people in order. Thank you. I think Julie Ford, you're the first to come up on my screen.
Lovely, thanks, Dave. Yeah, fantastic presentation, Mary. Thank you so much. What I find on a daily basis is just the complete and utter point blank rejection of mediation from solicitors. I do civil mediation, and things that could be easily mediated that don't even need to get to court, they don't need to bother the court with. Solicitors are like, no, it doesn't need mediation. How do we get past this? Because a lot of these are no win, no fee solicitors. So their focus is not the best outcome for their client. Their focus is their fees, because if they don't win in court, they don't get their fee. So mediation is of no interest to them. How do we get past that?
The no fee thing, I can't actually, I've no experience of, but I can tell you that the National Audit Report into Family Mediation of 2007 actually covers all this. It says, and this is something the MOJ ought to know about, but they probably haven't even read it these days. The legal LSC expects clients to mediate where possible, but some solicitors dissuade and prevent people mediating. My solicitor never mentioned mediation. I got a letter saying I'd declined it. When I asked about it, I was told it was another standard letter and to ignore it. My solicitor wrote to my partner's solicitor asking for mediation, but they refused and said it wouldn't work. There are ways of dealing with this if you think about it. It would require the procedure that I have described of parallel systems of mediation and solicitors with referral points to mediation. It would require, even in a no-win, no-fee case, the question about mediation assessment to have been answered, and it would have to be an assessment by a mediator, because before 1997, the assessment was done by lawyers, and they just said, oh, mediation won't work in your case, you can't agree, can you? And the clients would go, no, we can't agree, and of course it won't work, because that's the conversation that took place all the time. So it would involve some sort of compulsion within the process of no win, no fee to a mediator of the parties to hear about mediation. I can't second guess with no win, no fee how that would shape out, but it would require experts in that field to make it work. And the people probably best adapted to do this would be solicitor mediators or lawyer mediators who'd been involved in the legal work.
Okay. All right, thank you.
Thanks. Roger Levitt, you've got your hand up.
Thanks, Dave. Thanks, Mary. Thanks, Julie. I'll give some experience from the other end of the scale. I'm finding that, firstly, dispute resolution solicitors that I'm dealing with are what I would call much more mediation friendly than they ever used to be. I'm finding that there are many more pre-issue mediations than there ever used to be. And I noted, Mary, that you weren't too keen on pre-issue mediations, but I'm finding that quite often people are mediating based on draft particulars of claim and draft defence. So from the client's point of view, I think it's obviously it's hugely beneficial on costs without getting into an expensive case. But having said all that, of course, compulsion is on the way in some shape or form when the MOJ finish their deliberations. Yes.
I would say I haven't read because I didn't get to it because it was question time. I designed a functional dispute resolution system, FORCE, And I said there'd be set referral points to mediation assessment to hear about mediation from a mediator, not necessarily mediate. Either one, pre-issue with both parties' agreement. That's the first one. What I wanted to preserve us from is pre-issue where you can't engage party two, because that will take you hours and days of pointless unpaid work. Second, pre-issue, second was when a defensibly counterclaim is filed. So you pick up the ones that, because you get the best savings on costs at the earliest point. So if they both agree pre-issue to mediate on particulars of claim, brilliant. If they won't, then when they want to file a defence and counterclaim is the next point. And then you need the really big one, which would stop the worst costs outrages, which is the 20% of costs, total costs. And then there might, and at a set stage, the 20%, possibly another one at 50%, or a final one before trial. You'd get people in again. I mean, Dave did one years ago for us where it was about to go to trial, two flats, one over the other, with a dispute over noise. And I think the cost of putting in insulation between the flats was a single thousands. And the costs were 68,000. And the problem that was resolved by Dave with one flat owner buying the other out. Well, you know, it's a pity it got right before trial, but at least it didn't go up through trial, which would have doubled the costs. So I think these set referral points built into the court procedure, built into the court orders, built into the directions will do it. But you need to design them with the MOJ and the judges, because otherwise they won't be very practical necessarily.
I agree.
Thank you. Thank you, Roger. Jonathan Fingerhuts, I think you've got your hand up next.
Yes, hello, Mary. Thank you very much. I've sat here for the last 45 minutes nodding my head at what you're saying vigorously. I'm the cynic of how mediation is marketed or not marketed and so forth. I engage with the Department for Education quite extensively, has done for the last 20 years, was involved. They asked me to talk about the role of mediation in special educational needs and disabilities in the original Children and Families Act, where somebody who knew less than nothing about mediation was the civil servant in charge of writing that bit of the then bill. There is now a notional compulsion. Well, local authorities have to go to mediations where there is a dispute on an education and healthcare plan prior to going to tribunal. But parents notionally do, but often don't. And it's interesting where you talk about many of them have a psychosis or whatever. In education terms, many of them are about their autistic child or whatever, and of course that is inherited, and a lot of the parents, you sit down and with a minute you kind of go, oh, yeah. I see where we are. My question to you is, it's a hot debate at Sanctuary Buildings in London, the DFE, about what they should do with mediation and Senate. Do you have any thoughts based on your extensive, and I say this as a compliment, cynical experience about mediation in all the other areas, about where that might go? What is the possible way forward? Because this is all based on costs. The send costs are, you know, overspent by billions, and the government wants to bring it down. And again, they see mediation as a silver bullet of doing that, which is probably not the case. So yeah, where do you think one would go with
interestingly, the autistic and autism and Asperger's angle is frequently a problem in family mediation. Frequently. I can remember one particular case where I had child psychiatrist observing, because he'd just become a mediator. He just used the skills in his practice. And this man came in, and he had a dispute with the wife, with his wife, because they hadn't been able to have children, and they'd had adopted a little girl. And then he had an affair with somebody and got her pregnant. And by the time the marriage broke down, he'd also got his wife pregnant. So there was this autistic man who had 3 children, and he couldn't cope with it. He was in a complete state of, not funny really, but it was. And the psychiatrist said to me, he's autistic, and he can't cope with all these different children and process all the information. So he's completely flooded, and it's really difficult for this to work for him. We tried various strategies. None of them were ever going to work. The thing eventually solved itself because the girlfriend had a daughter and the wife had a boy. Anyway, it eventually was sorted through the courts because, as I said to you earlier, some people have got to be told. And this notion that you get these messy cases to mediators and they're going to have this magic wand. Has anybody got a magic wand? I used to keep one in my drawer, and I used to get it out at really bad moments because, you know, you can't actually do something for some people for whatever reason, and they need to go back into the other process and have it sorted differently. And that's why I think the ultimate goal has to be massive understanding, cooperation, and parallel working between solicitors and mediators. And that is a huge culture change for solicitors, more than mediators, because we're used to being in the one down position. I don't know if that answers your question or not.
Well, no, it's fascinating. I recognise all the things that you said. But I, as a non-lawyer mediator, and for those of you like Dave who've heard me say this many times, it's the most dysfunctional industry I've ever worked in, because 90% of mediations are done by solicitors, and of those 90%, probably 90% of them are done by the small group of 10% of the night. You know, it's just hopeless. And all the industry is good at is training more mediators who are desperate for observations, for whatever. And 95% don't ever, not only don't make a living, they virtually don't do any mediations. There are some exceptions, obviously, who do manage. But just to answer the question in terms of the Department for Education, and we're now on our 5th Secretary of State of Education so far. Like most departments, it's been particularly bad in education. So all the schools white paper and the SEND green paper are all in limbo, but the one thing they are talking about is cost reduction, and therefore how would one persuade more parents in terms of not individual talking to them to persuade them to go to mediation on a dispute, and it's often about where the local authority wants to send them to a maintained special school, and the parent wants this nice non-maintained special school, which costs.
Well, I think the answer is the same as the earlier questioner about how do you force the no-win, no-fee cases into mediation. At the end of the day, all these people have got to use the process for resolving it. And if mediation is a compulsory stage, in its consideration as a compulsory stage in that process, and actually attending an assessment meeting to hear about mediation and how it might work, and after a certain point actually attempting to make it work that way, is part of what's taken into account on costs and everything else, then it's more likely to happen, because what you're doing is changing the attitude of the users of the dispute resolution system. So instead of thinking they've got to keep going because they've got to win, they've got to win, they've got to win, and they've got to defend their child, and engaging all these fairly primitive survival instincts, you're engaging a much more rational element, because if they don't do X, Y, or Z in relation to mediation and actually attend the assessment initially, hear about it, consider attending a mediation, if they don't do this, they can't proceed to the next stage. And I think some of these, I don't know much about SEN, but what I've heard on the grapevine is not necessarily reliable, but some of it, the proceedings are almost used as a stick to beat the local authority into submission because of the costs of dispute. But I know from a teacher, stroke psychologist, a friend of one of my sons, that sending an autistic child into a physics lesson and expecting him to benefit from it at a high achieving school is a complete waste of time for him and not really helping him either. But parents can't always give up on these original aspirations.
I think the most telling statistic is that 96% of cases that get past any kind of mediation, often there is no mediation, that go to tribunal, 96% of cases hold against the local authority, i.e. the parent wins. 96%.
Well, that is fascinating, and one has to ask the question, why? Why is that? Is it because the local authority is always wrong? Or is it just they cave in because of the money side of it?
Well, they dispute it. It's when it goes to tribunal and the local authority will actually present to it. Like all these things, it's a mixture of factors, of local authorities not listening to parents and so forth. But it's quite a desperate situation. And as soon as the Daily Mail and the Sun get hold of this disaster that is there, it might then get to our new Prime Minister's ears. But and also the other thing, in conclusion, Dave, don't worry, I'm finishing now, is the awareness of mediation. It's appalling. I'm a marketing guy at heart, and for the last 5 years, I've been talking about more people need to be aware of the benefits of mediation. And I know, did you ever meet Paul Randolph?
Yes, I knew him very well.
Wonderful man. And he was as frustrated about, it's a brilliant product, which it is, but nobody knows about it. But
I can just say on that, there is no way people are going to suddenly overnight know more. There's no money to invest in selling it. The thing that will make people know more is if it becomes an integral part of the court proceedings that they are engaged on, and is known to actually be one of the main things that stops the costs going out of their reach. Then they will start to understand the benefit of it, and they will get to understand it better because it'll be integral to what they're doing.
Yes, I agree, and it's a huge mountain politically to have to rise to. Anyway, thank you very much.
Thank you, Jonathan. I think we've got time for one more. It's Jane. Jane Coxey, you've got your hand up, I think.
I wanted to, I was prompted by you talking about the need for us to lobby, and Jonathan's just raised this, that people just don't know about mediation enough. I went to the FMA conference this summer, and Sir Andrew McFarlane, President of the Family Division, spoke, and it was very disheartening. He seemed to not like mediators as far as I could tell. He talked a lot about new things that they might do. And there's a pilot going on to allow lawyers to do two-client model and basically tell family people what they should be doing in a sort of semi-mediation. And there's also pilots with doing things like NLP mediation or psychotherapist systemic psychodynamics. So they're apparently thinking about anything else but us, almost.
Okay. Well, I would.
So I stood up. Just let me finish. I stood up and asked him the question: would you like to know what the floor thinks? And I asked everybody to put their hands up if they had capacity to do more work. And of course, about 90% put their hands up, but he didn't seem to be bothered by that. So it's something about some negativity about our profession. That's
totally.
Happening. Yes, and
totally.
I don't understand why it's happening, but I do know that they all hate the form he talked about the form. We all hate this stupid form we have in family, the result of Miams, the one we sign, because it doesn't give the sort of information that's useful to any judge. But we didn't draft that, I understand. It was drafted by somebody in a lower position in the Home Office who didn't know what mediation was about. So maybe if we could just change the form, it might help. But we
Well, I'd love to deal with this question, actually. Just two things. The FM1 form, which you're referring to, does not require anyone to give a reason for mediation not taking place. And it says in the CMC's answer to the question 3 in the MOJ's questionnaire, it gives a perfectly acceptable reply, and then it says it's got to be reasonable refusal. If mediators are supposed to say whether a refusal to come to assessment was reasonable or not, it will be lethal. It will completely be the worst possible thing that could happen to you, because you will not know. You will be tricked into thinking it's one person's fault when actually it's the other person's fault. You will spend hours and days trying to deal with the fallout from that. The FM1 or civil CM1 or whatever you call the form, simply say that they've been to an assessment meeting, full stop, end of. Coming back to your other question, what you've just described reminds me of various events in my own long career over this. I can remember when the ADR handbook came in and we had all these compulsory MIAMs for all family court applicants. I can remember getting a letter from 2 judges in some county court on the south coast, which said, we do not approve of mediation, and we're not going to support it in our court, and we're certainly not going to do this, that and the other in relation to the case where there'd been a referral to mediation. And I went along, we used to have meetings at the county court, and I went along, I think it was Patrick Perusco or someone like that I gave it to. Anyway, he said, I'll have that, please. And he actually did something about it. But I can tell you that judges actually, quite a lot of them, do not want mediation, because there will be less work. And let's face it, it's their livelihood too. Whatever they say about supporting it, some of them do and some of them don't. And I can remember some very senior judge saying to me at some event in London years ago, well, my wife is a solicitor in a local family firm, and she tells me that these MIAMs are a complete waste of time. So we just think, you know, they're wasting time. We're not getting on with things. But of course, what they mean is getting on with things in the old way, where the proportionality on costs, the rule in the CPR, the FPR, doesn't mean a damn thing, because nobody knows what it means, because it's not specific. And it doesn't say joint costs are limited to 20% before somebody has to do something. It doesn't say that. And I've been at an FDR at the principal registry, where the costs, yet again, at the FDR have exceeded the difference between the classes, the parties, and the judge has said, it really is quite extraordinary how we get to the FDR. And the costs, funnily enough, just happen to be the amount of the client's dispute. But they are. And I think it takes a big change in the system to displace that and stop it happening. Lobbying, you can get pay for parliamentary lobbying. I think mediators might pay for it. When Mums for Medics were challenging the government with a judicial review, because of the system the government had brought in, which was underpinned with a faulty algorithm, so that all our medics' sons and daughters were not getting their training contracts. They sent out an email to everyone on Mums for Medics and said, we need to do a judicial review. This person's the top man. This is how much we need. They got the money by that afternoon. And on day 4 of the judicial review, the fact of the faulty algorithm eventually came out. And the person who had, Patricia Hewitt, had pushed it all through despite knowing about that and causing a massive disaster, really lost her career on the back of it. So there are things that can be done, and people may not want to pay the professional bodies for, I don't know, membership fees, but if they know that they're paying 50 quid for a specific budget to do something with lobbying, it might happen. It's just one option.
Thanks, Jane. Thanks for that question. And thank you, Mary, for that very interesting run through. I think everybody knows that meetings are on the second or third Wednesday of odd numbered months. So the next one will be in January. Before we go on to asking people to introduce themselves that haven't been before, I'll just ask Michael Cover if there's anything he wants to say before we move on to that.
Well, thanks, Dave. Yeah, we're hoping to, and we're in touch with this chap, Mark Beer, who's actually worked in the courts here in Dubai, where Martin and I are currently situated, and Dubai Arbitration Week. Dubai Arbitration Week's a bit like Car Phone Warehouse that doesn't just do car phones. So we've been talking about mediation and dispute boards. It's been very, very interesting what's going on here on the mediation front. So we hope to get Mark, and as soon as we can nail him down, we'll get a date in the diary and get a flyer out. So that's what we're hoping to do. So as Dave says, we meet bi-monthly, and if people have other ideas about speakers who may be able to tell us more about how we develop our practices and develop the market for mediation, that would be fantastic. So, and thank you everybody for coming along.
Thanks, Michael.